So the hassle-free eviction process starts off with a good lease. And so while in Texas it is legal to have a completely oral agreement with a tenant, it is not something that we advise. And so you should have a written lease which clearly delineates the obligations and the rights of the tenant, but also the obligations and the rights of the landlord. And so most people have a written lease, but many people don't know where to get one. Some will go online and simply do a search for a residential lease and will use something that's more appropriate for a tenant that resides in a different state. Sometimes people will use an outdated lease. Sometimes people will use documents that were not intended for residential leases, or they'll use a residential lease for a commercial purpose. If you're unsure about the quality of the lease that you're using or whether or not that lease is appropriate for renting a unit out in present day Texas for use under the Texas Property Code as it is currently written, consult an attorney. You're better off drafting a lease that you can properly use and stand behind than one that has holes that a good attorney on the defense's side can knock down and create more delay, more headache, and additionally create costs that you can prevent by starting off with a good lease. One of the things that I found representing tenants over the course of my time as a real estate attorney is that so many times the lease itself has imperfections that are very easy to correct. If you own property under the name of a holding company, for example, 123 Holding LLC, but you use a different name as the landlord, you perhaps use your own name as the personal owner, well, you've just created a fact issue that the court can entertain as a basis to deny you possession in an eviction lawsuit. So be careful and make sure that the parties are correctly listed on the lease so that when you file an eviction, it is very easy to tell that the person requesting possession is the person entitled to possession. Additionally, where it comes to the tenants, it's important in Texas that every person who is listed in a lease be mentioned in the eviction lawsuit, particularly if those people continue to reside on the premises. If you have 3 listed tenants who have signed the lease, but you only file an eviction against 1 tenant, your petition will likely be turned away by the court as ineffective and actually illegal. And so you want to be careful and make sure that the paperwork that you provide to the court and that you've provided to your tenant matches that which you're going to provide with regard to an eviction filing. Always maintained original signed copies. It's not often that it happens, but I've seen landlords who lose their copies of a signed lease or for whatever reason allow the tenant to keep a copy. And while this seems like a basic note, it's important to keep both a paper original, but also a digital copy. It is not difficult to make digital copies these days, and you're encouraged to go to a local business that might provide this service to simply keep on your email or in a digital file that you hold digital copies of all of your leases. Finally, you want to make sure that the language in your lease comports with Texas law. That could be as easily as presenting a copy of what you have now or what you plan to present to future tenants to a licensed attorney. A licensed attorney can take a look at what you have and assure you that what you have still comports with the law. There are a number of times where I've seen landlords come in with a very basic lease that does not properly inform tenants. And when I represented tenants in the past, I would attack leases like this as ineffective and illegal. And while it doesn't always win the day, it can buy time for a defendant who is seeking just that, additional time, where your highest and best use of the property is a tenant who's paying rent and who is following the law. But remember, it's also the obligation of the landlord to follow the law. And so we can help you make sure that your lease does just that. As far as the accounting goes, it's necessary to keep accurate accounting, particularly if you're collecting cash payments. If you're collecting cash payments from a tenant, you'll need to keep a ledger. Chapter 92 of the Texas Property Code requires that receipts be provided and that a ledger be maintained, particularly when cash payments are taken. Additionally, if you hope to prove default by non-payment of rent from a tenant, it's necessary for you to be able to display to the court an accurate means of accounting for each payment received and any fees assessed against the tenant. I'd like to also mention one common mistake that landlords make with regard to the application of funds. It's necessary to have good accounting of the amount of money that's coming in, but it's also a good rule of thumb to apply any payment that is received to the longest standing debt. Too many times landlords come in, receive payments from a tenant in month 3, when the tenant is 3 months behind, and will, for whatever reason, apply the rent to month 3 as opposed to month 1, which is the first month of delinquency. You're encouraged always to apply any amounts received to the oldest debt, including fees. And you'll want to read your lease to make sure that the ability to apply funds this way is locked in the black and white of your lease so that you get an optimal amount of income based on what the tenant owes, and so that you're not in a position in front of a court where certain months that you claim have been unpaid or remain unpaid were actually simply miscalculated because of a bad account ledger. As far as collecting late fees from a tenant when a tenant has failed to pay rent on time, your lease will inform you as to what the amount is that you can collect and the time in which you can demand such fees. My recommendation generally is, if you choose to waive any of these fees, not to do it more than once per calendar year. You may find that it creates good customer service or a good relationship to waive fees for a couple of days late here or maybe a week or 2 late there. Unfortunately, what you may create is a pattern from your tenant or tenants that will ultimately cripple your business. We do not encourage that if you do waive any fees, you do it more than once in a given year.